Published 10:47 Est, the 8th of November 2017. Updated 12:09 Est, the 8th of November 2017. Mary Griffiths, a wonderful mother and a kind and thoughtful woman, was dragged from her bed by John McFarlanepictured and shot in the chest. The High Court heard today the murder of a wonderful mother by the friend who became her stalker was preventable had action been taken by police and mental health staff. London's High Court has heard. Fitness instructor, Mary Griffiths, 38, was shot dead with a cattle bolt gun by John McFarlane in front of her three daughters, at her home in Bury St Edmunds in May 2009, just hours after she phoned police to say she was scared of him. Her daughters, Jessica, 22, Hannah, 19, and Sophie, 18, are now suing the Chief Constable of Suffolk Police, Gareth Wilson, and the Suffolk Mental Health Partnership NHS Trust for damages. They claim that, had steps been taken by the police force or the trust, their mother's death would not have happened. Opening their case at the High Court today, their barrister Nicholas Bowen QC said Mrs. Griffiths was a wonderful mother and a kind and thoughtful woman. He told Mr. Justice Ousley, hearing the case, that Mrs. Griffiths was terrified when she called police about McFarlane, who had been stalking and harassing her in the days before the murder. The trust had taken a decision not to detain him under the Mental Health Act at around 12:30 p.m. on May 3 and had come out to see him twice between then and the murder, he said. Mary called the police at 5:56 p.m. on May 5. She was terrified. She wanted them to come out, but, for reasons that we will investigate in this trial, they decided not to prioritize the call and did not attend. A call was made at 6:26 p.m. on May 5 to the crisis team informing them of the escalating situation by a friend, but the call was not picked up until the following morning. The primary responsibility was of course his, McFarlane's, but we say the murder was preventable. Had McFarlane been detained on May 3, or proper steps taken by either or both defendants on May 5 in accordance with their protective obligations under human rights law and the common law, the murder would not have occurred. The 40-year-old slaughterman had been stalking and harassing the terrified 38-year-old fitness instructor pictured in the days before the killing. Both the police force and the trust deny the claims against them and are defending the case. McFarlane, a farm worker, started behaving aggressively towards Mrs. Griffiths in the days before he murdered her after she rejected his advances. He had also attempted suicide and had sent her a number of concerning text messages. They argued on the 5th of May 2009 after he wrote a post on Facebook falsely claiming they had been a couple. During the early hours of the following day, he sent a text saying he was on a revenge mission and was going to kill Mrs. Griffiths' daughters. He then used an axe to smash his way into her home in Bulrush Crescent and dragged her outside, where he shot her twice with a bolt gun used for killing cattle. Her three girls, aged 13, 10 and 9 at the time, witnessed their mother's murder and two of them were involved in a struggle to stop McFarlane during which Jessica, the eldest, was injured. McFarlane, who now goes by the name James Alexander, later admitted her murder at the Old Bailey and was jailed for life with a minimum term of 20 years. Mr. Bowen told the court Mrs. Griffiths had phoned a non-emergency police number at about 6 p.m. on May 5 and told an operator McFarlane had flipped out and she was frightened of him. A staff member called back later that evening, at about 9:45 p.m., to say an officer would go and see her the next day. A stun gun similar to the one used to kill Mrs. Griffiths, a friend of Mrs. Griffiths, had also left a message with a mental health crisis team at about 6:30 p.m., saying she was really concerned as McFarlane's behavior was really erratic. Lawyers for the Chief Constable said the police had absolutely no reason to believe McFarlane would kill Mrs. Griffiths. In a written defense, Jeremy Johnson QC said he obviously posed a risk to himself, but there was nothing to suggest he would murder Mrs. Griffiths. Mrs. Griffiths herself evidently did not think that there was a real and immediate risk to her life, otherwise she would have asked for an immediate police attendance and, failing that, would have gone into hiding. In the event, she was content for police to attend the following day. Nothing in the content of what she said to the police could possibly lead to a conclusion that there was a real and immediate risk to her life. He added the police have enormous sympathy for the claimants. They are utterly blameless. They have suffered a dreadful tragedy and loss. They have a right to compensation from the Criminal Injuries Compensation Authority, albeit, of course, nothing can begin to remedy their loss. However, it is respect he submitted that they have not shown that the police acted unlawfully. The barrister said he would not be cross-examining the three sisters, or their witnesses, as the chief constable was anxious to make sure the trial did not cause them further grief or distress. Angus Moon QC, for the Trust, said staff believed McFarlane may harm himself but did not know he was stalking and harassing Mrs. Griffiths and, based on the evidence at the time, had no reason to suspect he was a danger to others. He added none of the Trust staff considered that McFarlane posed a risk to others as opposed to himself. He made no threat to Mary. The Trust contends that there was no assumption of responsibility, reasonable foreseeability is lacking, and there was not a sufficiently special relationship between the Trust and Mary to justify the imposition of a duty of care. The High Court hearing continues.